Hello, everyone. Thank you for joining us today. Our goal over the next 45 minutes is to help inform and equip you with the policy changes affecting private sponsorship that were recently announced by President Trump's administration and what steps you can take now to support newcomers. My name is Krista Kartson, and I'm the Senior Director for Sponsorship Initiatives with Welcome.us. I'm also a sponsor, which means I know you are eager to get to the heart of why you've joined today, as am I. So we'll jump right in. And as you all know, the new administration signed an executive order and issued a memo last week impacting humanitarian sponsorship programs, including the processes for Cubans, Haitians, Nicaraguans, and Venezuelans, and Uniting for Ukraine. We'll provide an analysis of these policy changes and how sponsors and newcomers are affected. We'll also have time for a live Q&A with immigration lawyer Dree Kalapi joining us from the American Immigration Lawyers Association and the American University. We want to recognize there were other policies announced that affect immigration other than sponsorship, but in this webinar, we will not address policy changes outside of those that impact private sponsorship programs. This event is hosted by Welcome.us. We are a nonprofit, non-government organization founded in 2021 to empower and equip Americans to participate in the work of welcoming newcomers, primarily through sponsorship. Please share your questions in the Q&A function, and we'll try our best to answer what we can today. This webinar is being recorded, and the recording will be shared on our policy page, along with continued program updates as we have them. So here to share what we know, we are joined today by Welcome.us CEO Nazanin Ash and our guest of honor, Dree Kalapi, who is an immigration lawyer, to answer your questions that are more legal in nature. Nazanin, I'll pass it over to you.
Thanks so much, Krista. Thanks everyone for joining us today. And thanks so much for the really deep care and concern you're expressing on behalf of people that you've welcomed and that you hope to welcome. As Krista mentioned, our intention here is to hold community with all of you who are navigating a rapidly changing policy environment, and to share as much information as we have as soon as we get it with the incredibly community of welcomers of which you are all a part. I want to start by sharing a little bit of context about the current moment that we're in and a little bit of background about what's happened to date and where we are today. As many of you know, the CHNV and the Uniting for Ukraine programs were launched in part because we're in the midst of an unprecedented global challenge of conflict and displacement. Some of you know our history as Welcome.us, that we were launched in response to the evacuation from Afghanistan when the administration at the time was faced with the enormous challenge of welcoming and resettling nearly 80,000 Afghan evacuees on a government resettlement system that in the previous year had welcomed just 11,400 refugees. And so the great insight here was that by tapping into the capacity and the willingness of all of our American communities, all of the people, just like all of you joining us on this webinar today, we would find far greater national capacity to welcome and have a much greater ability to respond to the urgent humanitarian crises that were unfolding. As all of you are keenly aware, that evacuation from Afghanistan was followed very quickly by Russia's invasion of Ukraine and the displacement of millions of Ukrainians who were immediately in danger, as well as multiple crises in our own hemisphere, in Cuba, in Haiti, in Nicaragua, and Venezuela, all of these countries experiencing enormous crises of state oppression and of violence and of persecution, and in Ukraine's place of invasion by Russia. We often think of ourselves as sitting at the intersection of crises that people were seeing around the world and what they wish they could do about them. So these programs were launched in response to the desire of Americans to help, and by making it possible for Americans to sponsor people seeking refuge from these countries who were experiencing successive crises, we found the national capacity to welcome many more. These programs, because of all of you and the way you participated in them, were enormously successful. And there are over 2 million American sponsors who have welcomed nearly 790,000 newcomers over the last 3 years, all through safe, legal, authorized, orderly pathways where people had security and background checks and vetting, were met at the airport by all of you, and were helped with their initial resettlement and finding housing and employment and self-sufficiency with the support of sponsors like all of you. So we really want you to see and know that you're part of a community that has opened their hearts to these newcomers through these safe and orderly and legal pathways. And as all of you know really well, this has had not only a generational impact on the lives of the newcomers that found a bridge to safety here through all of you, but it's also been deeply meaningful to those of you who have welcomed them and to the communities of which they've been a part. The Congressional Budget Office estimates that these newcomers will contribute $9 trillion to our national economy over the next decade. So it's a program that has worked so well to provide safety for people who needed it in a way that was safe and orderly and legal, and it has worked so well to help reinvigorate our communities and our economy. I want to take a moment, though, to talk about the legal authority through which individuals were welcomed, because this is where some of the changes are coming into play. Humanitarian parole is a legal authority that's been used for nearly a century by both Republican and Democratic presidents to help respond to urgent humanitarian crises. It's a temporary humanitarian immigration status that allows individuals who are facing urgent humanitarian crises to enter the United States legally. So think, for example, of the collapse of Vietnam and the need for many, many Vietnamese to be evacuated to safety. It was used back as far as President Eisenhower, who admitted nearly 30,000 people from Hungary following the collapse of an anti-communist revolution. It's been used throughout the 60s, 70s, 80s, 90s with presidents of both parties to establish programs that helped hundreds of thousands of people fleeing persecution from Cuba, from Vietnam, as I mentioned, and from other areas to arrive safely in the United States under those circumstances where safety needed to be provided urgently. So most recently, as you know, it was used to help Afghans after the takeover of their country by the Taliban in 2021, by Ukrainians after the Russian invasion in 2022, as well as for Venezuelans, Cubans, and Nicaraguans fleeing persecution from authoritarian leaders, and Haitians seeking safety after the collapse of their government and the violent targeting by gangs in their communities against people who were unwilling to join in violent activities. But it's a designation that relies on presidential authority. So it's a designation that Congress has provided presidents the authority to use this humanitarian parole pathway when they see crises that they designate as being necessary for the use of this pathway. So presidents can designate it, and presidents can also choose when to end it. But as I mentioned previously, everyone who comes through these pathways pass through background checks, security vettings, financial reviews, and a review to identify their need for safety. And the idea is that once they're here in the United States, they have 2 years of status to be able to apply for more permanent, durable status. And we'll talk a little bit more about that in a moment. As Krista noted at the top, these programs are changing rapidly with the change in the administration. And we want to share as much information as we have, and we'll continue to do that. So keep checking back on this website. We'll send you follow-up emails because we want to make sure you have information as soon as it's coming out and as soon as we understand its implications. What we know has happened so far is that programs for sponsoring people from Cuba, Haiti, Nicaragua, and Venezuela have been ended. That means that no new applications are being accepted. And the program Uniting for Ukraine has been paused. That website is still operational. It seems like they are still accepting applications, but it sounds like application processing has been paused. And as I mentioned, for the CHNV program, no new applications will be accepted. So those programs are in a state of uncertainty about what the future looks like for applications that have already been received. In the case of U4U, uncertain whether the program will continue. For people already in the United States who have already been received to these programs and received their humanitarian parole status, the administration issued a notice late last week that gave immigration officials the discretion to decide if they wanted to review cases of individuals who are here on humanitarian parole to determine whether to end that parole status and begin the process of removing them from the US back to their home country. So this means that it could possibly impact people who arrived with humanitarian parole status through the CHNV as well as the U4U program, and possibly humanitarian parolees from Afghanistan as well. Because humanitarian parole was used expansively in response to these expansive crises, Afghanistan, CHNV, Ukraine, over the last 3.5 years, there are, as I said at the top, close to 800,000 individuals who are here on parole status. And again, the administration's new policy is authority given to immigration officials to undertake the decision to review cases of individuals on humanitarian parole and determine if they should be if their parole status should be ended and the process of removing them should begin. So it's not a blanket policy change. It is the giving of discretion and authority to immigration officials to make those decisions on a case-by-case basis as they may think appropriate. I will note, though, that we've already, we know that it's worrisome information to hear. And we have heard already that there have been individuals who have already been asked about their status. We know that with respect to programs that were paused, that there are individuals whose travel authorization was canceled. What we're seeing is really inconsistent implementation of the policies that have been announced. We don't know yet how the guidance will be fully implemented or whether and how it would be enforced, but we're eager to share the information we have, and we're eager to hear from all of you about what you are hearing in your communities, what questions are arising. It'll help us as we continue to provide these information sessions to make sure that we're being as responsive as possible to the experiences that you're seeing across the newcomers that you've been supporting or others in your community. In response to these policy changes, there's a really important step that sponsors and newcomers can take now to help protect themselves and apply for more durable status. So, as I mentioned at the top, humanitarian parole is always a humanitarian visa that's provided on a temporary basis. The idea is that there isn't time to do the full assessment of whether you need long-term safety in the United States, while you are in the midst of being evacuated from Afghanistan or fleeing Russia's invasion from Ukraine, as an example. So the idea with parole status is you come to the United States on a temporary basis because you're understood to have a credible fear. And then while you're in the United States, you apply for more durable status if you're eligible. So, for example, Cubans who have been in the United States for a year are eligible to apply under the Cuban Adjustment Act for permanent residency in the United States. Afghans who arrived through Operation Allies Welcome have been applying for asylum pretty consistently, and the asylum approval rate has exceeded 97%. Haitians, Nicaraguans, Venezuelans, they can be, for Haitians and Venezuelans, they can be applying for temporary protected status. It's a more long-term protected status than humanitarian parole. But your eligibility depends on when you arrived. That's the case for Ukrainians as well. But for all of these populations, asylum is also a possibility if you're eligible, and that's really determined on a case-by-case basis. So we offer this as a summary chart to think about what more durable statuses the newcomers you've welcomed may be eligible for. But as we often say, it's really important to evaluate your individual case and to get support from an immigration attorney as needed. And that's where I'm going to turn it back over to Krista and to our special guest, Dree, to answer some of your immigration legal questions.
Thank you so much, Nazanin. And please, as you submit your questions, my colleagues are selecting some of the most common ones that will benefit as many folks who have joined us as possible. While they gather your live questions, some of you may have joined us last Friday, where we hosted 2 more private community conversations with sponsors and welcomers after the Department of Homeland Security memo was issued, to hear what folks were experiencing on the ground in your communities and what questions they had. And some of those questions that were more common in that space on Friday, or some I wasn't able to answer because I don't have the legal background that our colleague Dree does. So I'd like to tee up a couple of those here as we gather your questions to tee up in just a moment. And the first question, Nazanin, is for you. This is one of those questions I didn't have an answer to in the moment, but someone asked, has a lawsuit been brought to stop the changes made by the executive order?
So we're not aware of any lawsuits that have been filed yet to pause changes under this executive order. But we do know that there are a lot of organizations that are thinking about it and that are still trying to understand its implications and how it might be enforced and implemented. One of the things that we've heard from so many of our sponsors is a lot of confusion and bewilderment around why these lines have shifted. And by lines, I mean, it's important that these were programs that all of you and the newcomers whom you've welcomed participated in, that were legal and authorized at the time. And while, as I mentioned, humanitarian parole is a presidential authority that presidents can decide when to use and when not to use, part of what is still unknown is what happens if there are status changes while people are still within the time of their designated original parole. And what I mean by that, and Dree, you'll do a better job of addressing this, but you were given a parole visa for 2 years. That means you have 2 years to apply for more durable status. What happens if those rules change while you're in the midst of your process? Do they apply to you or do they not apply to you? That's still something that is unclear.
Thank you, Nazanin. And one more question for you. And again, this came out of our conversation on Friday as we were really had just had the opportunity to look at the memo as the general public. It mentions something about discretion, and the question was, to what extent do states have their own discretion in enforcing the memo and the guidance provided in the memo? To what extent do the local immigration and customs enforcement or ICE offices have their own discretion to enforce it?
Yeah, I thought this was such a thoughtful question from our sponsors, like sort of a concern right away that because there are not criteria that have been defined for whether and how immigration officers should assess people who are on humanitarian parole, sponsors very early raised a concern that that left a lot of room for discretion. And yes, there is right now a lot of room for discretion. We haven't seen criteria defined for whether, when, and how immigration officials should use the authority that's been given to them to evaluate newcomers who are here on humanitarian parole. It's why we suggest that newcomers with humanitarian parole status should apply for more durable status as quickly as possible, ideally asylum if you're eligible, because in general, deportation efforts are not directed at those who have a pending eligible asylum application. It can be protective while these new policies are being better understood and implemented.
Thank you, Nazanin. And to your point, given all these nuances that we're still understanding about how this policy will be implemented, we've had a number of questions specifically about how at risk are these cases at for like looking at and evaluating each individual case, like including the Uniting for Ukraine program. We know that the executive order didn't specifically mention it, but it was referenced broadly in the memo. Dree, do you have more insight on like how the impact or the risk that Uniting for Ukraine beneficiaries have?
So, like everything that we've been saying, we don't really know yet a lot of the answers to these questions, but what we do know is that Uniting for Ukraine was not specifically mentioned. However, the memo and the executive order seem to imply that it would also, these policy changes would also apply to Afghans and Uniting for Ukraine. The executive order specifically, mentions that it applies to any categorical parole program that was initiated by the Biden administration. So that certainly would include Uniting for Ukraine. It is, promising, I think, that the website is still up and active, but we don't know, how long that will be the case. And so I think, it would be wise for all of you as sponsors, and thank you, by the way, for your generosity and support of these families. It's really inspiring, and I know you're committing a lot of time to making sure that you're helping your sponsorees know and secure their rights, and that's really commendable. So thank you all for what you do. But yeah, I think it would be really wise to continue educating yourselves on the other potential options that the sponsored families might be eligible for. And I think it makes sense probably to have a consultation with an immigration lawyer to fully understand each individual's families or each individual's specific eligibility for these various other potential options. Every case is different. Every person's circumstances are different. So, that's my number one recommendation, is to consult with a knowledgeable attorney. And also, we can talk through more tips on how you can protect your families and advice that you should pass along to them today. But there's a number of things that people should probably do to try to secure their rights and put them in the best position possible moving forward.
Thank you very much, Dree. And I don't think we could overemphasize enough the importance of seeking legal counsel. That's, as you all know, as I shared in this space and multiple webinars, I'm a sponsor as well. And that's a step that we're taking this week together. And we don't know what the next step is going to be after our consultation, but what we decided is to just have a consultation, understand our options that are specific to the case, and then talk from there. So it's really just one step at a time right now. Nazanin, your hand is up, so I'm going to call on you.
I wanted to respond to, I'm scrolling through the questions, and I'm just going to reinforce that we'll try and group them and answer as many as we can here. And ones that we don't answer, we'll do our best to follow up and post FAQs. There are two that I'm seeing repeatedly that I want to make sure we answer. One, if someone that you have sponsored has already applied for and received asylum, that status will not change. So if they've already applied for and received asylum, that status will not change. The same for folks who came through the Welcome Corps or through the the traditional refugee resettlement, U.S. refugee admissions program. If you arrive with refugee status, or if through the asylum process you are granted asylum status, those are permanent designations. and these policy changes do not apply. And so I just want to make sure people hear that clearly and can have that confidence. With respect to temporary protected status, this is a designation different from humanitarian parole. It's confusing because both of these legal statuses are temporary, but temporary protected status is still a more durable, it's a longer term status than the 2 years of humanitarian parole. We have not yet seen executive orders or policy changes impacting TPS, temporary protected status. That has been those programs that were, that where there are programs that exist for Ukrainians, for Haitians, and for Venezuelans. But as you saw in the previous chart, depends on when you arrived. Third thing that I want to make sure everybody hears clearly, everyone who arrived through these humanitarian parole pathways, CHNV, people from Cuba, Haiti, Nicaragua, Venezuela, people from Afghanistan, people from Ukraine, if you were issued a humanitarian parole visa, you are here legally. That is a legal status that you have now. You were also, those newcomers were also eligible for work authorization. I just want to make sure we clarify those 3 things. Over to you, Krista, sorry.
Thank you for that clarity, Nazanin. I think jumping right into what you were chatting about, we remember that we saw that chart. I didn't see re-parole on that chart, but we're getting questions about that. Understanding that, humanitarian parole is a status, can folks still apply for re-parole, and should they? And so this question is for either of you.
Dree, I'm going to give that to you.
Sure. Yeah, so it's with the programs being ended, I think that being able to apply for re-parole or an extension of your parole based on an ended program is probably not going to be fruitful, unfortunately. But there is, humanitarian parole exists under the law beyond these specific programs. And so, and it's discretionary, but even if the program has ended, it might be beneficial for the individual, even if they're not eligible for some more durable status, to consider just applying for regular humanitarian parole, which still exists under the law. And, that is, I think, one tip that I would have is starting to gather, for people who have parole currently, starting to gather evidence of the urgent humanitarian reasons or significant public benefit reasons for them to be granted or to continue in parole status. That can be useful if the government agencies take steps to try to terminate their parole, or otherwise end these programs, so they can try to protect themselves in that way. But yes, I think continuing to apply for humanitarian parole for programs that aren't ended, I think you definitely they should do that, and consider maybe seeking humanitarian parole outside of the boundaries of the terminated programs as well.
Thank you, Dree. And to do that, if we were to apply for humanitarian parole outside of these programs, is it very similar to the process that we as sponsors participated in filling out that I-134A, or what does that look like?
So USCIS, their website, U.S. Citizenship and Immigration Services, has a whole page about humanitarian parole, just the general form of humanitarian parole. So that's a really great place to look first. It walks you through all the requirements, but yes, it's a very similar application. It's not nationality specific. So, and it doesn't, it doesn't respond to these specific crises. It's just something that has always existed under our laws. So, but that would be the best place to look first, is at the website on uscis.gov.
Thank you. I think the distinction here, and correct me if I'm wrong, is that the executive order referred to categorical humanitarian parole programs. So that would be programs like CHNV and U4U, but this broader humanitarian parole that you just mentioned doesn't fall under that order because it's not categorical. Is that right?
That's correct. So it's something, like I said, that has existed. And what the Biden administration did with initiating these categorical programs was say, hey, this benefit exists under the law. And what I'm going to do is I'm going to apply that benefit to this specific group of people to respond to a forced displacement crisis. And so that's, ending those categorical programs doesn't end humanitarian parole as a concept.
I see. Thank you. That's so clarifying. And that's why, we update our website, our policy updates page regularly with Q&A and updates as we receive it. But we never hold back information. We're never going to hold back information to share in one of these webinars. But it is so important and it's valuable to us to have these conversations for y'all because there's so much nuance as well. In addition to the black and white FAQs that we share. So Dree, I just want to pause in the middle of our time here to thank you and thank you all for joining. I hope this is insightful and we want to keep bringing you all helpful, insightful, nuanced material because it's a big topic. And even in that spirit, our next question is so thoughtful. It says, does the administration have the ability to remove people prior to their 2-year date listed on their parole form? And what would qualify for a reason that could be? What guidance can we provide as sponsors to folks who we sponsored to keep this from happening?
That is a good, thoughtful question. And it shows, I think, very intelligent foresight, given the language of the memo, the implementing memo that was issued on Friday, I think, or the end of last week. So yes, since humanitarian parole is discretionary, it can be terminated at any time. And that was the case before these executive orders as well. And so, if it is terminated, then the person who was in the humanitarian parole status would then be out of status if they hadn't already applied for some other type of benefit. And so being out of status then, of course, would put them at risk of being removed from the United States if they're here without a valid status. One thing that was so concerning about the implementation memo and some of these executive orders that aren't specifically about the parole program, but have to do with other policy changes, is the expansion of something called expedited removal. It's a fast track deportation process that enables people to be removed from the United States without a hearing before an immigration judge. And previously, that policy of expedited removal was only applied near the border and only applied to people who had been physically in the United States for less than 2 weeks. But what the Trump administration has done is say that they're going to apply expedited removal to its full extent available under the law. And so what that means is that they can apply it to anyone in the interior, no matter where you are. You don't have to be near a border, and to anyone who has been in the United States for less than 2 years. And so I imagine that would apply to a lot of the people that you all have sponsored, that they've been here less than 2 years. And so for those that have been here for 2 years, I would recommend that they gather evidence of that, of their physical presence in the United States for 2 years, and carry that with them in case they are ever come into contact with immigration agents. They can then prove that they can't be subjected to that expedited removal. And, the other thing, again, I think that what you should do is have a consultation with an attorney and see if there's any form of status that your parolees can apply for in the meantime, because relying on parole at this point, given how some of the programs have already been terminated, and given how the administration has spoken about humanitarian parole, I think it makes sense to try and apply for other benefits as quickly as possible for your sponsorees.
Thank you, Dree. And what about folks with humanitarian parole status, or who came through a humanitarian parole pathway and have been in the country for less than 2 years? What advice should we give sponsorees in those conditions?
Yes, so I would say, again, apply for another form of status if they're eligible as quickly as possible. And I would say carry around evidence that you have applications pending for additional benefits. I also think it's really important to, if they do have an attorney, for them to carry around a form called a G-28, which is a form that the attorney signs that says that they represent that individual, and that way the person can provide that form to any immigration agent if they are apprehended or questioned, showing that they have an attorney, and that they're not going to respond to any questions or provide any documentation without their attorney present, or without their attorney's advice first. And then there's various Know Your Rights documents that can be provided that you should go over with your sponsorees, just to make sure that they know that even though they're not citizens of the United States, they have rights here. Importantly, neither you nor your sponsorees ever have to open the door to your home to an immigration agent unless the immigration agent has a search warrant that's signed by a judge. And that's important because ICE agents oftentimes have a warrant, something that says it's a warrant, but it's just basically an immigration warrant, but that doesn't permit them to enter the home. And so you never have to open the door or let any immigration officers inside your home unless there's a signed search warrant by a judge. Additionally, you don't have to speak to immigration agents. There's a right to remain silent. You don't have to respond to their questions, neither do your sponsorees. You don't have to sign anything or sign any documentation without first having the opportunity to review it with an attorney. And so sharing these points with, I think, your sponsorees is really important, because a lot of times people think that they don't have rights here if they're not a citizen, but that's not the case. So, these things are really important to kind of empower the sponsorees to protect their own rights and to self-advocate if it becomes necessary.
Thank you, Dree. I'm learning so much personally. I know we're at time, but we're going to keep going. If you both have just a few more minutes, we've got a couple more questions. And also, I think with the number of questions and your thoughtful answers, I have more questions once I hear your responses. So I think we might need to ask you back again soon. I know this is your second time joining us, and we're so grateful for your expertise. I'll just ask one more question, and then we'll move on. And all of your questions are so helpful for us to add to our Q&A, our growing resource of Q&A on our website. So we'll make sure you get a link again to that before you leave, and in your post-webinar email, but we'll just take one more live question now. And I'm just going to read it because there's some legal stuff in here that I don't even quite understand myself, but I know you, Audrey. So the question is that we're getting a lot of questions specifically about Ukrainians applying for asylum. And it might be because it may seem less obvious that Ukrainians could be eligible for asylum. So if someone from Ukraine is in the US now under humanitarian parole and maybe they're not eligible for TPS, does it make sense for them to apply for asylum, assuming they have a realistic claim, even if asylum later is not successful? And two, if they apply for asylum, does it prejudice their ability to apply for another visa category, such as an E2?
Okay. So when people are applying for asylum, it doesn't halt their ability to apply for anything else. So you can apply for multiple things simultaneously. If someone is eligible for asylum, they should most definitely apply as soon as possible. On timing, there's something called the 1-year filing deadline, which is a rule that basically says people have to apply for asylum within 1 year of their entry to the United States. Otherwise, they're barred from eligibility. There's exceptions to that, however, including if someone has been maintaining some other valid status, such as humanitarian parole. So my advice would be that people apply for asylum as soon as possible if they're eligible, and while they're still maintaining their humanitarian parole, and not to wait until that expires to apply. Are Ukrainians eligible for asylum? Possibly, yes. Again, asylum is a very complicated area of the law, and there's a lot of different eligibility factors that have to be proved in order to be granted asylum. And so an individualized assessment of each individual's claim by a qualified attorney is really important to do. But generally, yes. I've filed asylum applications for Ukrainian applicants recently. And it depends on the individual's factual circumstances. But again, I would recommend consulting with a lawyer. I put my email in the chat there because I know we won't have time to get through all the Q&As today. As Krista said, they'll do some follow-up and get your answers, but I just wanted to offer myself as a resource as well. Please feel free to reach out to me anytime. I'm happy to answer quick questions by email and also help you get set up with a consultation if you're wanting to go that direction and find an attorney.
You are so generous, Dree. Thank you. Thank you so much. You are such a resource to this community. We really appreciate you. And we co-developed a guidance document that I'll ask our colleagues to drop in the chat as well. And this document is specifically for navigating alternative sponsorship pathways. It's not up on the screen, but we want to make sure that you have access to that because it also includes a few links to identifying legal resources in your community and what might be available nationally as well. So please be sure to take a look at that, and you'll receive that in your emails as well. As sponsors, I'll just say for myself, as a sponsor, my first priority is supporting the newcomers who I've welcomed. I sponsored them over a year ago, celebrate with them, and we, walk alongside each other now. And so the next step that we have is we're going to speak with a lawyer this week. That is my first priority as a sponsor. And then my second priority is also sharing the impact that sponsorship has made in my life and in my community with my representative. I know where I'm from in Cleveland, Ohio, there's a big Ukrainian community and many have come through humanitarian sponsorship. And I want to make sure that our representatives hear about it and know what a benefit newcomers have been to our community to continue the legal status of these programs. And so if you want to join me in that, in contacting your representatives as well, Welcome.us created a guidance document about how you could do just that. What we can expect in our advocacy work, in the work that we do to contact our representatives and share about our programs. This is the webpage that you're seeing on the screen. That's what you'll see when you open up the link that my colleagues have dropped in the chat. The next page shows the guidance document. So this is just the top part of the Google Doc that you'll see. You'll see there's two sections. One is if you are checking on a specific case that you want to understand if a case is still pending, what is the status of that case. And the second section is guidance for how to communicate just your support of these programs more broadly and the impact that it's made in your community. And this could be a really helpful resource even for employers, for neighbors, for donors, as they want to continue to help supporting newcomers and share. This is a great resource for them because if you click on the link in this document, it will take you to a page like this. You just put in your name and your address. Again, I'm using a postal code from Cleveland, Ohio, where I'm from. And then that will show you who your representatives are, your national level congressional representatives. And it has a pre-populated email, but you can modify it. You can delete it all, and you could write whatever you'd like in that email, because we know that personal messages are important to receive. But regardless, showing your support for a program like this can really be transformative in lifting up your concerns and your questions to your representatives and putting it really on their radar in a time that they have, I can only imagine, really busy schedules and a lot of people contacting them. This is a way to share your voice as well to your representatives. So you can modify this copy and then you just click submit. And then they'll receive an email. And the next slide just shows it's just a simple email with whatever content you included in that form is what they would receive. That guide also has more information. We know that calls are really important for our representatives because it shows that you're taking actually time out of your day to express your thoughts and your support. And so we, even in that original guide, we have a script that you might use and instructions on how to find the phone numbers as well for your representatives' offices. So with that, we're going to have a webinar on February 6th to learn a little bit more. We're going to hear from sponsors about their experience contacting their representatives, and you'll receive an email after this webinar with a link to register for that. We'd love for you to join us. Even email us at sponsor@welcome.us if you have an experience that you want to share and speak on our next webinar. Reach out to us because we'd really like to talk with you. We'd love to hear from your experience. Stay up to date on our policy page as well. As I mentioned, we're updating those regularly. I had colleagues working over the weekend to make sure that you had information at your disposal as we receive it. Contact your congressional representatives. As I mentioned, I've got that meeting with the lawyer this week, but I also have my sponsor group coming over tonight, and we're gonna send some emails and then even ask our donors to do the same, because it wasn't just us who sponsored, but a whole community alongside of us who eagerly welcomed the newcomers that we sponsored, as well as and who want to stay in touch and stay engaged to continue expressing their support. So we're going to talk in our own community about how we can do that too. So I just would really appreciate, I know we've already taken so much of your time, and we appreciate the time that you've invested in us. I hope you found this to be helpful. As we close the webinar, you'll see a survey. Please fill that out, because that helps us to understand, is this the right content that will be helpful to you in this time? Is there something else that we can be responsive to? We only create these resources because sponsors like you ask the questions, the thoughtful questions that you do, with the care and consideration that you do. So we want to continue hearing from you, and we're so grateful. So on behalf of all of us at welcome.us, know that your compassion and dedication to supporting newcomers inspires us every single day to do the work that we're doing. Thank you so much. Nazanin, Dri, thank you for your time. Everyone, thank you, be well, and we'll see you soon on February 6th.
Thank you all. Well, thank you. Thank you.